We have with us Charles Gallagher of Gallagher and Associates. Mr. Gallagher has a practice that, in addition to foreclosure, focuses on financial services litigation, insurance claims such as sinkholes, toxic mold and hurricane claims, mortgage litigation, predatory lending, and negligent underwriting claims, business litigation, and consumer law. So without me flapping my gums anymore, Charles, welcome and thank you for being here tonight.
Thank you for having us. Welcome everyone. We have a program to go through, but I want you to also feel free to ask questions if in between the slides anything comes up that might be in your situation. Also afterward we're going to have an opportunity to talk about specific cases and the like, and we also have in the back a assignment sheet, so if you want to come in to our office for a free consultation to go over in a little more depth your case, we can go ahead and do that too. So that being said, let's go ahead and talk about the very, very beginnings of notes of mortgages and foreclosures as this topic. First of all, whenever you sign your house, at your house closing, you had two separate documents you sign. You sign a note and a mortgage. And everyone talks about the mortgage interchangeably, but there's two separate documents. Both of them are contracts, both of them have legal obligations. With regard to the note, it's a payment obligation. Okay, so they can't take your house by breaching a note. They can only get a judgment against you for having to pay that note obligation. With regard to that, if you breach it, there's a money judgment against you. That would mean that a court would say you owe the bank blank dollars. Now, if you have your mortgage in breach, what happens there? Well, your mortgage is the collateral for your house. It's a security for your loan. If you breach the mortgage, you're taking the house back. So what happens if you breach the mortgage? They're going to take your home out of it. Take your home back. Now, what happens at the end of the day, at the end of foreclosure, if you've done nothing at all? Well, you breach both of those, and you lose your home, and you've got a judgment against you for the amount owed on your note, which is a deficiency judgment. You keep hearing about this phrase, deficiency judgment. Something you should be worried about? And the answer is absolutely. You can have a scenario where you think you might lose your house, and that's it. You're done. You're foreclosed. You're out of the home. It's the end of the day. That's not the case. Whatever you owe on the loan will likely be what you owe the bank after you've been foreclosed off of the property. And this is what's called a deficiency judgment. This is where the bank will go ahead and have a judgment against you on the foreclosure. They'll go to a foreclosure sale. They will bid a nominal amount, and the remainder of that nominal amount, typically $100, is what you owe. So say they have a judgment against you for $200,000. They're going to bid $100 at the foreclosure sale. You still owe them $199,000 and $900, even though you're out of the house. It's the real danger here. Now you hear about all these great, the predicates of the default. Well, what are the issues? So first of all, the first issue is you fail to make your payments on your mortgage. Second issue is you're going to get a notice from the bank that says you're in default of the mortgage. You have not paid your mortgage, you owe us money. What's going to happen next is called the acceleration of your mortgage. What that means is that not one payment's due, but the entire balance of your mortgage is due upon failing to make your payment, then failing to go ahead and make that up. So say you owe a mortgage payment of $1,000, and you don't make that payment. 30 days pass. They come back to you and say, hey, you need to pay your mortgage payment, or we're going to accelerate your mortgage. Presume the mortgage has a balance on it of, say, $180,000. At that point in time, you owe the bank $180,000, not the $1,000. That's the acceleration. Now, what happens in the event of that default? One is you'd be allowed to reinstate the mortgage by paying the amount that's due, not the accelerated amount, but the amount of payments. The lender can allow that, or the lender can say, no, we're not going to allow that to happen. This is a very unlikely scenario where you can what's called redeem the mortgage. So say, for example, you won the lottery, or you had a family member that gave you an inheritance, and you can actually redeem outright the amount of money owed to the bank. Now, how are we going to know these things are happening? You're going to get what's called a demand letter from the bank. It's going to be a certified letter, a letterhead from the bank that says, you owe us money. You didn't make your payment. If you don't make your payment, we're going to go ahead and accelerate your mortgage and sue you in foreclosure. So it's be very careful if you get any kind of certified letter from the bank that says, pay us money, you're in default. Very, very important. You've heard a little about this nationwide mortgage foreclosure settlement, okay? And can this help you? Is this helpful? Is this going to be an option for you? The first issue is that all 50 states participated in this. problem is the lack of meaningful relief for homeowners nationwide. And here's what I mean by that. Say, for example, your home was foreclosed wrongfully by fraud. You get $3,000. That's it, nothing else. Okay? Say, for example, you were one of the lucky ones to get a reduction of principal to your mortgage. The best you're going to get is $11,000. Okay? And for people that are underwater to the tune of $100,000 or more, it's really not going to help. Now, there are penalties for certain lenders who have failed to comply with standards nationwide, which is going to help the government, but not going to help you. And the final issue is, say, for example, you lost your home in a fraudulent foreclosure. The settlement does not mean that it's going to get undone or you're going to get back into your house. This only helps people going forward and paying those nominal amounts of money for fines. Now, what kind of programs are out there that might be available? And I'll give you at the outset the warning that these programs have proven to be very, very unfruitful. There have been attempts in Congress to go ahead and abolish them altogether because the success rates have been so very, very low. Stats have said that somewhere around 2% of loans that were submitted for help, for evaluation, have been evaluated. Not been granted, not been rejected, have been evaluated. So what's happening is these lenders are getting all the applications in their offices, and they're sitting on a shelf somewhere, and not getting evaluated. When someone calls in and says, well, what about my application? And the bank says, well, all your records are stale. They're all very old. Well, they're old because they sat on that one shelf. So they're telling people to go ahead and give us more current financials, more current applications. We're filling those out. At the end of the day, these programs have been not very fruitful across the board. They have provided some help, but it's been very isolated. So the programs that are out there are under Making Home Affordable. One is called HARP, which is the Home Affordable Refinance Program. Just what it sounds like. You're able to refinance under preferred rates. The next one is called HAMP, which is the Home Affordable Modification Program. The ability to modify your current loan on better terms. Typically, it's going to be only addressing the amount of interest and the payment, not principal. The next program is called 2MP. Say, for example, you got a second mortgage, you got a HELOC, some other loan on your property, second mortgage, some other second lien. This will help modify that second lien so that it's not burying you in debt. The next one's called UP. It's Home Affordable Unemployment Program. This provides short-term assistance if you're underemployed or unemployed, not a long-term fix. And the final one is called Home Affordable Foreclosure Alternatives Program. And this might be something as little as a short sale or a deed in lieu that's by a government program. Now, under Home Affordable Refinance Program, here are the eligibility requirements. You may be eligible if you're the owner of the home, it's a 1 to 4 unit home. Your loan is owned by Fannie Mae or Freddie Mac. That's a big problem there. If it's a portfolio loan owned by Bank of America, Wells Fargo, or somebody else, you may not be eligible under this program. It's got to be a government-owned loan, Fannie Mae or Freddie Mac. At the time you apply, you've got to be current on your mortgage payments, which you're already in default most likely, so it's going to be excluding a lot of folks at the outset. Also, you're going to have the amount you owe has got to be your first lien mortgage. You cannot exceed 125% of the current market value of your property. What this means is that your underwater effect can't be more than 125. If it is, you're not eligible. And finally, based upon these elements, you have to have the ability to repay the new mortgage payments and to refinance and improve the long-term affordability of your loan. So we're talking about a permanent fix, not a temporary band-aid. The next program is HAMP, Home Affordable Modification. You can qualify for HAMP under these circumstances. One, your home is your primary residence, not a second home, not a vacation home, or rental property. Two, it's an ironic number. Not a lot of folks are there either. You owe less than $729,000 on your first mortgage. You got your mortgage on or before January 1, 2009. And your payment on your first mortgage is more than 31% of your current gross income, including taxes, insurance, homeowners association dues, and you can't afford a mortgage because of some hardship, like a job loss or medical bills. Most of these programs are going to require some kind of predicate hardship. You got a divorce, an illness, a job loss. Something's got to be asserted as a basis for why you're asking for this help. Under the 2MP program, second lien, you qualify for this if one, your first mortgage was modified under HAMP. Two, this is not an ironic one, you're not convicted in the last 10 years of any felony, larceny, theft, forgery, or any other kind of real estate fraud type transaction violation. you have not missed 3 consecutive monthly payments on your HAMP modification, so they want your HAMP modification to be performing and going permanent, and then if you make your three payments in a row, you're eligible. The UP program is next. And here we have a forbearance plan if you meet certain criteria. Forbearance just means withholding of your payment for a temporary period of time. It does not mean we're taking away the payment, it's mean we're erasing it. The first issue is going to be secured by a 1 or 4 unit property, one of which is your residence. So if it's a scenario with a duplex or triplex, that would count. 2, the mortgage has got to be the first lien that's got to originate on or before January 1, 2010. Home Affordable Modification Program, HAFA, has the following elements. 1, the property options available with HAFA include a short sale. Okay, this is where a scenario occurs where if you're underwater, you owe more than your property's worth. You want to sell your property, and the bank is permitting you to sell it for less than you owe. And that's a short sale. Short sale is where you're going ahead and selling it to somebody else, a third party, and the bank is taking less than you owe. There's also a scenario called a short pay. Banks talk about short sales more, but there's some scenarios where the bank will say, you don't qualify for a short sale, you qualify for a short pay, in which case you pay the bank a certain amount of money to induce them to go ahead and go forward with this. The other option is called a deed of renewal foreclosure. This is where, during the foreclosure process, or before foreclosure process, you agree to sign a quitclaim deed to the bank and give the house back to them in lieu of them filing a foreclosure action against you and litigating the foreclosure action to its fruition. So you're just going to go ahead and give the property back as an option. You know, commonly asked question, I'm paying my mortgage, why would my lender help me? I'm underwater, I need help, why would they help me? Okay? It's all about cash flow. The lender has no incentive to help you out at all. If you're making your payments, the lender's getting the money every month from you, why would the lender want to go ahead and reduce that cash flow or reduce what they're getting on a monthly basis? It's not in their best interest. Their incentive is to go ahead and maintain their asset and maintain the cash flow. So the second you go ahead and stop making payments, then they have an incentive to go ahead and help you out. Well, and everyone also asks, with all the government programs, my lender will help me out, right? Wrong. Again, the stats are somewhere between 2 and 3% of all these programs get evaluated. Don't get approved, don't get denied, they get evaluated. And about 3 summers ago, there was a program where Obama had pushed to have, and these are his words, not mine, the Department of Treasury, quote, stormtroopers that would actually be in the offices of different banks and servicers and lenders and ensure that they were actually evaluating these applications as opposed to sitting vacant and not acting upon them. And that was also, they tried that, it didn't work, and the program remained to be still very unfruitful. Foreclosure 101. We need to know what this all means. A foreclosure lawsuit, the summons, all these things. What do these things mean? Well, the first issue is you're very lucky that you're in Florida. Many states are what's called non-judicial. That means that somebody can foreclose on your property by sending you a certified letter. That's it. Okay? Florida requires court intervention. You have to file a lawsuit in Florida court. You have due process protections, and you've got to litigate the case through its entirety before they can get your property back. And then many states that are not this way. Court intervention is required to take your home. There's no way we can take it without having a court being involved. The first thing you're going to get in the lawsuit is a summons and a complaint. The summons would tell you you've been served, you're now in a lawsuit, you've got to respond to this lawsuit within 20 days, or else you're going to get defaulted. And be defaulted in a court context, not in a mortgage context. 20 days to respond. You've got to respond to whoever served you the lawsuit. So you're going to serve a response to the court and a response to the attorney for the plaintiff, attorney for the bank. And whatever that response is will be too late. Like 20 days to respond. If you fail to respond, the court hears what's called a default. And that's very, very important. If there's one thing I want to leave here today, everybody to leave here today, is that you don't want to get a default entered against you. A default is fatal. Okay? Default waives all of your rights, waives all of your defenses. Say, for example, you paid all your payments, and you failed to go ahead and respond to the court proceedings, and you failed to respond. That defense of payment is waived. You can't go ahead and use it anymore. You've lost that for good. Say, for example, there's been a robo-signer who signed one of your documents, or a wrong party suing you. If you don't respond within 20 days, if all gets entered, you're done. It's all over. You've waived that defense. Very, very, very important. Now, the phases of a case, phases of litigation. So the first phase is going to be the lawsuit being filed. The next phase is going to be a phase called discovery. That's where you have to go ahead and get the documents get the proof, find out whether you paid your mortgage, whether you didn't pay your mortgage, who owns your loan, all those kind of nuts and bolts of the lawsuit that support what the lender said. The next phase is motion practice. They're going to file a motion for summary judgment, a motion to dismiss, a motion for continuances. Those things are all where the court will resolve certain small issues, smaller battles within the greater war. And the final phases is mediation. Now in Florida, there's a mandatory mediation program under foreclosure cases. This means that the lender is going to pay for a mediator. A mediator is non-binding. Okay, it's not like arbitration, not like a trial. Essentially, everybody goes into one room. A mediator will try to go ahead and bring sides together. You go ahead and pay them this, you go ahead and do this, you go ahead and agree to this, you try to go ahead and get a voluntary settlement. It's not involuntary, and it's not required. So the mediation is required, but it's not required to take or take any offers. You can go ahead and do whatever you want to do voluntarily. Court docket issues. Now, I'm sure you've seen press on this and the problems in the state of Florida. Florida is in a bad way. Okay, over 500,000 people have active foreclosure cases in the state of Florida. 500,000. Okay? 1 in 5 Americans are underwater under their mortgage, and 50% of all Floridians are underwater. Okay, so it means we're hurting as a state. We're in a bad place. Add that to the fact that the courts are overburdened. The Pinellas County Court has confirmed over 31,000 foreclosure cases. Okay? New cases are being filed at the rate of 1,000 per month. Each trial judge has a docket of over 3,400 cases. They should have a docket of about 400 cases probably. So the whole system is being overburdened and overtaxed. And what that means is that it's been a slow resolution for these cases. Because normally it takes about 18 months, 24 months to have a foreclosure go full force and full term. Now, these judges are under time constraints. They're under constraints that they have to dispose of these cases within a certain amount of time. And what they're trying to do is they're using rocket dockets. They're using rocket dockets and accelerating proceedings where you lose some of those rights. They're getting retired judges, senior judges, and magistrates to go ahead and resolve important issues, important legal issues that involve due process issues and involve rights that you have under Florida law. As a result, that what I would call fast food adjudication of these cases has been bad and has been very, very hurtful for the consumer's rights in Florida. Foreclosure defense. What is foreclosure defense? You default on your loan, you think you're done, you think that's all you have to work with. Absolutely not. There are defenses here, both factual and legal, that can be used to defeat a foreclosure. Not just go ahead and try to settle with them, but to defeat them. First issue is very, very important to resolve here is the burden of proof is with a bank. Okay? We had a trial about a month ago. We were suing a bank was suing our client. At the end of the day, we won the trial. The reason why? The bank couldn't prove they owned the loan. There were two parties that claimed they owned the loan, the same loan. The court said, well, if you can't own it, I'm going to give the defendant a judgment in their favor. So the burden of proof is with the bank, not with the defendant. The fancy term for this is contractual conditions preceding. The easy way to say that is there are certain things under the mortgage they're required to do. For example, that demand letter, that acceleration notice. Those letters you're supposed to get under the terms of your mortgage that when you're in default, you can go ahead and pay money to cure it. If they don't do that, they're going to have problems with these what's called conditions preceding under the terms of your mortgage. Ownership of the loan. So the video with Scott Pelley. One of the biggest issues right now is who owns your loan. You may have a robo-signer, you may have that's filing a lawsuit against you, you may have a servicer, you may have a lender, you may have a trust, something you've never heard of. In most of these cases, people come to our office and I say, well, who's your loan with? My loan's with SunTrust. Well, why is Bear Stearns in the front of the complaint? Why is Wells Fargo Trust in the front of the complaint? One of the biggest issues is you want to go ahead and look back who your loan is with. And if your lawsuit comes through and you see some name other than that, that's a big, big red flag. You have an ownership issue with regard to a defense. Again, we talk about the tender of notice of borrower. They've got to give you the notices that you have to comply with the loan, to get certain time frame, certain rights you have under the loan. What about making payments or lost payments? You have a scenario where you might have the bank misapplying payments, the bank might be applying them monthly. One of the things banks will do is they have a dirty trick, they're called suspense accounts. Say, for example, you make your payment on January 1st. You made it on time, right? That payment goes into what's called a suspense account. And that account is going to be a holding account, in theory, for your check to clear. Well, say you had a late payment deadline of 3 or 4 days. Well, that 3 or 4 days it's in the suspense account, a late payment accrues. They go ahead and apply that from the suspense account to your account. At that point in time, they have triggered a deadline, they've triggered a default, and as a result, you got late fees that weren't your fault. Now, what's important about that is that the mortgage has a certain term that they can apply your loan. When your payments are late, they can apply your payment any way they want to. They can apply it 100% to interest, attorney's fees, to default fees. They can give $1 to principal. They can do anything they want to. So they want to trigger a default under your mortgage with this suspense account or intentionally lost payments under your mortgage. Standing to sue. The issue of trust, the issue of servicers and who owns your loan. Again, the only person that can own you, the only person that can sue you is a person who either you have a loan with or they have designated the authority to contract for them. For example, your loan's with SunTrust, your mortgage is SunTrust, SunTrust can sue you. Now, SunTrust can designate that right to somebody else to service their loan. ABC Loan Servicing, Wells Fargo Loan Servicing. But they have to go ahead and have documented writing that proves that up. So they can't go ahead and designate that to a servicer. But who can't sue you is someone who has no authority under your loan. So it's very, very important to go ahead and look at, they have, quote, standing to sue. And that's the next issue too, is real party and interest. Say, for example, your loan's with SunTrust, okay? And I myself am Wells Fargo, and I say, you know what, you need to pay me money. Well, you're entitled to say, how do we get from SunTrust to Wells Fargo? That's like Charles saying, I own your loan, trust me, I'm not going to give you any proof. If you don't give me the money, I'm going to sue you. Well, you're entitled to that proof. You're entitled from how a loan got from SunTrust to B to C to anybody else. So real party interest is very, very important with regard to a defense. The final big line heading is the robo-signing and lender mortgage fraud. Okay, as you saw in the video with Scott, there were countless scenarios where you had not only people, these title companies, but you had people that worked at foreclosure law firms, paralegals, attorneys, associates, whatever it was, and they were signing documents as vice presidents for certain banks. Now, never mind that they came to work that day as an attorney, they were doing work as an attorney, and then they were told, sign this document as vice president for Wells Fargo Bank. Did they ever get a paycheck from Wells Fargo Bank? No. Did they have a card from Wells Fargo Bank? Absolutely not. But this whole practice was called vice president for a day was invented and used with many of these different servicers, lenders, and law firms. So if someone's signing a document, in your case, a signing a mortgage, and a loan, a note, anything at all, they've got to be somebody who actually was an employee of the bank at that time and place. And one of the ways to check for this is look at the notary block. In many of these cases, you can go ahead and the notary block will be overextended or pre-extended. So for example, in Florida, notaries last for 4 years' time. If you have a notary block that was a notary block that says 2010 on the stamp, and the document was purported to be signed in 2001, that couldn't exist. It didn't come into play until 2004 because of the nature of how these terms work. Factual defenses. These are also very important besides legal defenses. So the first one would be payment. Say, for example, you paid your mortgage, the lender has used a suspense account, has triggered late fees, and you did nothing wrong. That's the defense, payment. Second defense is loss of payment. During these transfers back and forth between lenders, where the loans are being packaged and bundled and sold from lender A to B to C to D, there are scenarios where they're losing payments in that chain. And if you make your payment, you can prove it up, and the bank says you can make your payment, that would be a defense. If they lost the payment, you can prove it up. There's application of payment. Again, that same scenario where they are triggering late fees intentionally in order to put you further in the hole. The second they got your payment, they're going to apply to your account. They can't hold it for a week, they can't hold it for 7 days, wait for late fees to accrue, and then apply to your account. Suspense accounts, that's what I was talking about all along. These accounts that banks use in a very creative way to ensure that you're going to default on your mortgage, and they can apply your loan any way they want to, payments any way they want to. What happens if you get a default letter or demand letter from the bank? Now, you're entitled to this. There's case law in Florida, a case recently in the second DCA came out that said, if you don't get a demand letter, if you don't get your default letter, that the mortgages you're allowed to get, they can't foreclose on you. It's a required condition proceeding to the mortgage, and if they didn't do it, then you can't get it. Acceleration preconditions. For example, they've got to tell you, you've got 30 days to make payment under the loan. If you don't make a payment under the loan, we're going to foreclose on you. So we have to go ahead and have them give you that notice beforehand. If they give you that notice within 10 days, They give you that notice it's part of the lawsuit, bad as well. You've got 30 days under your mortgage to make your account current before they can accelerate your mortgage. Offering pre-foreclosure assistance. If your lender or servicer took money under TARP and other programs, bailout programs, they're required to offer you pre-foreclosure assistance. They're required to give you help underhand. So if your lender is one of those that took money, they're required to. But beyond that, there are other federal statutes. If you have a HUD mortgage, if you have a certain mortgage that has a certain dollar limit on it, you're required to get pre-foreclosure assistance before they can file a lawsuit against you. Here's the biggest one of all. How many of you have called your lender and said, I need help? And the lender has said to you, I can't help you when you're current, but if you default, I can help you out. Default. And then people go ahead and default, and the bank, and they call back later and say, hey, you told me to default, can you help me out? At that point in time, no help for you at all. The same case we had with the trial, and one for our clients, they had asked them 4 years prior to the trial date, please help me out. What were they told? They were told, stop paying your payments. Stop paying your payments, and we're going to help you out. If they stop paying their payments, they never were helped out. So that's one of the problems that a bank has got to get over, is that if they told you to default, you defaulted, and they're going to sue you, all you were doing was doing what they told you to do. So, big problem. Legal defenses. These are a little bit more nuanced, but we'll go ahead and give them. Again, standing to sue. There's a scenario where the name on your loan and note matches the name on your lawsuit. Okay? Say Bank of America is on your note and mortgage. Is Bank of America also on your lawsuit, or is it somebody else? If it's somebody else, we've got to go ahead and figure out why it's somebody else. We have to figure out how it got there. Did it get there by an assignment of mortgage, by a loan, by an endorsement? How did it get there? If it did get there, the possibilities were to get there legitimately, but oftentimes it did not get there legitimately, and they're suing wrongfully. Again, the real party in interest. Is it a trust? Is it a company? Is it a servicer? Who is it? And what's their authority to sue you in this lawsuit if they're not the party whose name is in the note in the mortgage? Servicer investor issues. How many times have you seen these cases where the name of the case, the style of the case, is a trust? The trust, the Wells Fargo ABC Trust versus Mary Smith. In that case, the real party interest is not the trust, it's the investors, whoever's investing in the trust or whoever the owners of the trust are. So in order for you to go ahead and settle your case or try to resolve your case, you're not dealing with the trust, you're dealing with the investors above them. So how do we know who they are, and how do we know if they're legitimately here lawfully? Verification of pleadings. About 4 years ago, the Supreme Court of Florida said, we're seeing a lot of problems in foreclosure. We're seeing fraud, we're seeing misconduct, we're seeing lender-based misconduct. As a result, we're going to require every attorney and every lender to sign under oath that this is a true and accurate document. The verification of these documents has been confirmed, and it's true and accurate. So there's been a requirement to go ahead and verify the pleadings, verify the complaint. And some people have complied, some have not. The next issue is, again, say our target example is you have a loan with Bank of America. You have your note and mortgage with Bank of America. Now your lawsuit with Wells Fargo. How do we get from A to B? Not only do they have to prove how they got from A to B, they have to attach that document. You can't just go ahead and say, yeah, we went ahead and sold the document from Bank of America to Wells Fargo. You have to go ahead and attach an assignment of mortgage from Bank of America to Wells Fargo to your lawsuit. And that way you know, and you've got proof of how that document got there and how standing now rests with the party suing you. The next issue is planning for trust. If a plan for the trust, trusts have to be registered in the state of Florida. Very, very few of these trusts are registered. And one of the easy ways to defend these things early on is to get the state of Florida Department of Corporations to confirm this trust is not registered and licensed in the state of Florida. If it's not, it can't do business in Florida, like any other business. It's going to be licensed in Florida to do business in Florida. So that's one of the big defenses. Is you're planning for trust? If it's a trust, figure out whether or not it's legitimately licensed in Florida. Pooling and servicing agreements. If your mortgage is a trust, very likely you have an underlying agreement, which is called a pooling and servicing agreement. What this is this pools all of the thousands of mortgages in your pool, okay? And that tells the servicer how they're going to go ahead and administer that pool. Are they going to go ahead and do deals with people? Are they going to go ahead and foreclose on mortgages? Are they going to go ahead and allow short sales? What are they going to do, and how are they going to resolve these cases? So you want to find out whether or not your mortgage is subject to a pooling and servicing agreement. suing banks for fraud. This is my favorite thing of all, okay? We don't just go ahead and defend foreclosures. We end up suing banks for their misconduct and their fraud. And you can use that yourself as a method to coerce leverage and to go ahead and settle your cases. The first issue is unlawful collection and servicing. Now, say, for example, again, your loan is with Wells Fargo. And say, me, just Charles Gallagher comes in and says, hey, I own your mortgage. You need to pay me some money. And you say, well, Charles, I don't see any proof here that you owe my loan. I don't care. Pay me the money. I'm going to foreclose on your property. How is that not fraud? Banks have gotten around the whole issue of regular fraud like everybody else and have thought that they can just go ahead and say, trust me, I own your loan. They'll give you proof of that. However, that misconduct of trying to collect on a loan that you're not entitled to enforce amounts to fraud in the sense, so civil fraud. The next issue is breach of contract. Again, we're talking about those conditions in the mortgage that say you're entitled to get certain notice, certain times to cure, certain letters, certain default letters, and things like that. If you didn't get one of those letters, the lender's breaching the mortgage, not you. If you didn't get an acceleration notice, you didn't get a notice of default, you didn't get a cure letter, those are things that you're entitled to under the terms of your mortgage. The mortgage is a contract, therefore the failure to give that to you is a breach of contract. Now say that your lender is saying, well, yeah, we're going to help you out. We're going to go ahead and give you options. Now, give me your financial documents, let's evaluate them, find out what's good for you. And they give you an option that's not good for you at all. They give you, say you have a mortgage where your payment is $1,000 a month and the interest rate is 4.2%. And your lender goes ahead and evaluates your stuff and says, we're going to give you an option here for a modification where your payments are $2,000 a month and 6%. Okay? Those are bad terms. Those aren't good for you. You already had terms that were favorable. They're giving you bad terms. They're breaching their fiduciary duty to you. Now, this is an area where there's not a lot of case law on it, but courts are being more and more sympathetic to lenders now and saying that when a bank is looking at the finances of a person, of a borrower, whether it's a regular loan or whether it's a modification or refinance, and when that bank says to you false things, for example, this loan is good for you, and the bank knows it's not good for you, that's a fiduciary duty issue. They've got to go ahead and be truthful to you and straight with you, and they can't misrepresent whether or not a solution is good for you. That's a problem. The next issue is negligent underwriting. Now, the best way I can describe the way loans were written over the past 7 or 8 years before this whole thing happened was banks were throwing money out of moving cars. They weren't asking for documents, they weren't asking for income, they weren't asking for verification. They were giving you anything you asked for. Okay? And I'll give you an example of how bad it gets. There was a product out there that all banks had called doctor loans. Okay? They figured if you're a doctor, you can pay for the mortgage, no problem. We're not going to make you ask these horrible questions. Doctor loans each had a rep. They would call the bank up and say, you know what, I'm Dr. Smith. I'd like to have a mortgage. Okay, Mr. Smith, Dr. Smith, what would you like? $500,000. Perfect. When do you want to close? 20 days? Not a problem. We'll be there. No problem. We'll have a warranty. That was all that was done on the underwriting for doctor loans. They didn't ask verification of income, verification of employment, verification of their MD. None of that happened at all. That was how banks underwrote loans back in that time frame where all these loans were going to happen. Now, Fannie and Freddie have set the tone for how you underwrite a loan. They say you have to ask certain questions, you have to verify certain information. Lenders were not doing that. They were ignoring those standards and underwriting any way they wanted to. And the worst example of all was Countrywide. Countrywide had these scripts where they would say, to apply for this loan, you need to have income of $48,000. You do have $48,000 of income per year, correct, right? Oh, yes, I do, of course. Well, and to verify this loan, we have to go ahead and have you working for the past 7 years. You have worked for 7 years, correct? Oh, yes, I have. That was how underwriting loans went at Countrywide. They would go ahead and prompt people the correct answers. Now, is that loan fraud on the part of a borrower? Not really. They're being led. They're being coerced. Is that underwriting fraudulent on the part of the lender? Absolutely. That's false information that they're giving them to parent. The next issue is just straight out lender fraud. Okay? I don't have a document that gives me an assignment of mortgage from Bank of America to Wells Fargo. I'm going to create one. I'm going to go ahead and go to one of these companies that will go ahead and get a high school kid to sign an affidavit of mortgage or assignment of mortgage and file that with the public records and say it exists. And that's pure fraud. That's just pure lender fraud. The next issue would be deceptive trade practices. I'll give you an example of one that happened 2 Christmases ago with one of our clients. There was a foreclosure suit filed. Our client had retained us. We responded to it. And a collector came out to the house for December 18th to 20th. And And the collector said to the little girl outside, I'm really sorry. I'm really sorry that you're not going to have Christmas this year. So the little girl said, what? Mom came outside, Dad came outside, said, you know, your house is going to sale tomorrow. Unless you pay me right now, $100,000, your house is going to go to foreclosure sale, and you have no Christmas. What are you going to tell your kids about no Christmas? How are you going to tell your kids no gifts for them? None of this was true. They had to respond to our lawsuit. They had to respond to our discovery. You had a person from the bank making clearly false statements, clearly fraudulent statements to these folks under the guise of scaring them into paying something when it was knowingly untrue. And that's the case where we've been referring to law enforcement because it was so fraudulent. It wasn't a matter of civil fraud, it was probably criminal fraud. Standing to sue. I talked about standing before. I want to go ahead and pin this down for you. Okay, there's a case out of Florida's courts called Lizzie v. McCollum. What that case says is, as a matter of law, the party seeking to foreclose a mortgage must prove standing to sue as the owner and holder of the loan. You can't say, trust me. You can't say, I'll prove it later. You got to go ahead and go in with your guns blazing and say, this is my loan, I'm proving it to you. This case of Barazio, this case out of our district here, the 2nd DCA. In that court, there was a trial judge who let someone say, trust me, I own a loan, without proving it up, and the court here reversed that judgment of the lender where a dispute existed with regard to who the owner and holder of the note was. Again, they didn't prove it up. They assumed that they owned it, they claimed they owned it. Here's their old big daddy law right here. Country Place versus JP Morgan Chase. This says, it goes even further than that. It says that if you're a bank, you file a foreclosure lawsuit against somebody and you don't own the loan, you're going to get sanctioned with monetary damages because of that action. But here we have a case where the 2nd DCA said the lack of standing was sanctionable under this act. It goes further and says, in the court of the court, deficient standing was never cured and remains a bar to the foreclosure. And here's the other big part too. Okay? Case law holds that a party cannot, after acquiring standing, and cure deficiency. What that means is that it's not something you can fix after the fact. You better have all your T's crossed and your I's dotted when you file your lawsuit. You better have standing proven. You can't fix it after the fact. You can't file a lawsuit and say, oh my gosh, crap, I forgot to go ahead and get standing. You go ahead and get assignment of mortgage after the fact. You cannot do that. You've got to prove that at the outset. If you don't prove that at the outset, you can never go back and fix it after the fact. It's not something you can retroactively fix.